Welcome to today's video. I'm Richard Chepo. I'm a privacy lawyer in San Diego, California. Today we're talking about the California Privacy Rights and Enforcement Act of 2020. So you might be thinking, the what? I've never heard of that. And you would be correct. This is not actually a binding law at the moment. It is an initiative. And to understand what it's about, you have to first step back and understand that California has a new privacy law called the California Consumer Privacy Act, the CCPA. It goes into effect January 1st, 2020. Now, the CCPA was originally a ballot initiative, and it received enough signatures. It was going to go on the ballot in 2018. But there were a lot of drafting problems with the initiative. It conflicted with other laws. There were parts of it that made no sense, so on and so forth. And so a political compromise was received. The initiative was taken off the ballot, and the California legislature went ahead and passed the CCPA, which is essentially the initiative rejiggered a bit to try to get rid of some of the more difficult areas. Now, the parties came forward at that point and said, the legislative parties came forward and said they would amend it, they would fix all the problems, and here we are 2 months before it goes into effect, and of course they have not. So there have been amendments, however, and the amendments have been somewhat controversial. Privacy advocates feel they've gone too far and watered down the CCPA, while companies tend to feel they haven't gone far enough and are creating a nightmare situation. So, what does any of this have to do with California Privacy Rights Enforcement Act of 2020? It is a ballot initiative brought by Alastair Mactaggart. He's a developer. He's a big privacy honk. He was one of the backers of the California Consumer Privacy Act. Obviously, he feels it was watered down a bit and that it needs to be expanded upon, and that's what the California Privacy Rights Enforcement Act of 2020 does. So basically, it's giving more control to consumers. We're seeing more of a trend towards GDPR requirements, although there is no legal basis, but we're seeing some of those additional protections, if you will. So it does things like it provides a right to correct inaccurate personal information to consumers, creates a new sensitive personal information category that will attach to things like debit cards, driver's license numbers, your social security number, your sexual orientation, biometric data, your religion, union membership, so on and so forth. And these will be given more protections. They will not be allowed to be shared unless certain requirements are met, things of that sort. People will be allowed to also exercise the right to stop having their personal information sold for advertising purposes. So we're talking about, pretty significant development there. And basically, it's just a continuation of the idea of sort of taking back control from companies on the use of personal information. Of course, the collection and monetization of personal information is a rather profitable niche these days. And so this, again, would be a reaction to that and place more and more restrictions on that practice. Now, there is a silver lining in that the CPREA contains a change to one of the threshold tests. So if you are a for-profit business, you need to determine if you need to comply with the CCPA by looking at 3 different tests. One is, do you have revenues in excess of $25 million? Second one is, do you collect or sell or buy or purchase personal information regarding 50,000 California consumers or households in a year? And the third one is, do you derive more than 50% of your revenues from the sale of personal information? Now, of those 3 tests, one of them kind of sticks out like a sore thumb, and that would be the 50,000 number. And the reason for that, while 50,000 may sound like a substantial number, it actually isn't. When you spread it out over a year, we're actually talking 137 data collection points a day. So if you collect information from California consumers at that rate, well, you're going to have to comply. Now, that's going to sweep up quite a few small businesses, and that's both offline and online. But particularly in the online environment, if you think about a scenario where maybe you have a popular app, maybe it's free, you could easily hit that number. Same thing with social media, same thing with a forum site. It's a pretty low number, and a lot of people have complained about it. I have to the legislature, and for some reason they were just not willing to change it. So the interesting thing is that the California Privacy Rights Enforcement Act would bump that number up to 100,000, which is a much more reasonable number, I think. But the interesting thing when you start thinking about this is, well, if that's the case, then why didn't the California legislature already change it? because if companies are saying it should be busted up to 100,000, and Alastair Mactaggart, who's the backer of the CCPA and one of the bigger privacy hawks out there, has obviously thinks it's fine because he's put it into this initiative, why didn't they do it? And this is the frustration that you get when dealing with political entities that are trying to resolve errors or perhaps unwise choices in ballot initiatives. For some reason, it didn't happen, and so this initiative would hope to fix that problem. So we'll see how that plays out. Now, the California Privacy Rights Enforcement Act would also create a new agency in California because, we don't have enough government agencies. This one would be called the California Privacy Protection Agency. It would be run by a 5-member panel. And as you can guess from the name, it would be basically governing Privacy Act, privacy law compliance in California, and pursuing enforcement actions. So basically, it looks like we would be trying to move some or all of the obligations out of the Attorney General's office, because we know there hasn't been quite as much enthusiasm for the CCPA from the AG as I imagine the backers originally thought there would be. Not to say that there aren't going to be enforcement actions, but it's just, I don't think they were happy being saddled with that additional duty. Now, when does all this go into effect? Well, it will be, if it makes the ballot, which it looks like it will, it would be voted on in the next election. I believe that's November 2020, the presidential election, and then it would go into effect January 1st, 2021. It would not replace the California Consumer Privacy Act. It would merely amend various provisions and add quite a few new provisions. So the CCPA compliance that you're working on now, you still need to keep working on it. Now, there's also a more global issue here that we need to think about in privacy when we're considering the proposed ballot initiative, and that is if it goes into effect on January 1st, 2021, well, it might not have that big of an impact, because I imagine right around that time or soon thereafter, it's probably our best chance to get a national privacy law. And the reason for that is, of course, we have a presidential election coming up, and with the political climate in Washington right now, people are screaming about impeachment at the moment. Well, it doesn't seem likely that we're going to get much legislation enacted. However, typically after a presidential election, we go through this little post-election glow period of maybe 180 days, maybe a bit shorter, where suddenly we do get a large amount of legislation passed, because at that point, the winning and losing parties are pretty clear as to who prevailed and who didn't. And so you can get legislation pushed through. Now, given the current political climate in Washington, who knows how long that period lasts, but traditionally that's been the way it works. And we desperately need a national privacy law, because every state, not every state, but most states are enacting their own little privacy requirements, and it's just chaos. So a national privacy law would essentially supersede all of those state privacy laws, or at least for the most part, and would simplify things. We would, practically speaking, probably have one set of rules that we had to comply with. And even if they were burdensome and quote unquote bad rules, it would still be better than having to deal with all the different rules that we have from every different state these days. Again, not every state, but it just seems like it. So keep an eye out for that. So anyways, the California Privacy Rights Enforcement Act of 2020 may be short-lived. It may be essentially invalidated if that national privacy law is enacted. What would then happen to the new California Privacy Protection Agency? I don't know. Perhaps they become masters of computer solitaire. We'll just have to wait and see. So anyways, that's it for today's video. If you have any questions, feel free to post them below, or you can reach me at SoCalInternetLawyer.com. If you are interested in privacy law changes and requirements, feel free to subscribe to this channel, as we'll be posting all kinds of information on the CCPA, the CPREA, and any national privacy law developments. And if you enjoyed the video, consider giving me a thumbs up. If you did not, I feel shame, and give me a thumbs down. So anyways, have a good one.